So the Supreme Court recently refused to hear a major challenge to the National Firearms Act, which involved suppressor restrictions. And now we're seeing the real-world consequences of that decision and that denial. Because after the Supreme Court declined to take up this case, the plaintiff in this challenge has now officially been ordered to surrender himself to the federal prisons, and he has to do that later this month. But at the same time, another issue has now developed in this challenge because Mr. Peterson is also continuing to challenge his conviction based on ineffective assistance of counsel, likely arguing that his original attorney failed to properly raise some critical 2A arguments under Supreme Court landmark decisions in cases like Bruin. So let's break down what is now happening. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply by subscribing. You can also hit the like button that just tells the algorithm that you appreciate this content, and so it shares it with more people. Also, I want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, the Attorneys for Freedom, and they're always trying to expand upon their benefits to give you as much as possible as a member. So if you're interested, you can check them out using the links down below. And right now, if you sign up using my code ARMEDSCHOLAR, you can get $50 off of your individual sign-up fee or $25 off the family sign-up fee. Now, as I mentioned in the intro, this all stems from the Supreme Court's recent denial of review in a case called U.S. versus Peterson, and that was a major suppressor and NFA challenge that was coming out of the Fifth Circuit. This case involved a challenge to the constitutionality of the NFA as it applies to suppressors. Now, essentially back in 2022, law enforcement executed a search warrant at Mr. Peterson's home and allegedly found a suppressor, but was actually a solvent trap in his bedroom safe. The ATF claimed that that unregistered solvent trap was a suppressor, and therefore he was charged and convicted of violating the NFA. Now, Mr. Peterson challenged that prosecution, arguing that the NFA's registration and taxation framework violated the Second Amendment. Now, on review, the district court rejected those arguments, and the case eventually went to the Fifth Circuit. Now, at the first review of this case, the Fifth Circuit actually suggested that suppressors were not protected arms at all, but then the federal government changed its position because, of course, the Trump DOJ got control of this case, and they actually admitted that suppressors are in fact protected arms under the Second Amendment. That forced the Fifth Circuit to withdraw its original ruling, and they issued a new decision. And even after recognizing that suppressors are in fact protected arms, the Fifth Circuit still upheld the NFA and this conviction against Mr. Peterson. The Fifth Circuit's reasoning was extremely critical and actually very concerning. The court essentially treated the NFA like a shall-issue licensing system. In other words, the court suggested that as long as the government processes applications objectively and does not exercise broad discretionary authority, well, then the system could still survive constitutionally, even when protected arms are involved. That reasoning immediately raised concerns because it potentially created a framework allowing the federal government and state governments to heavily regulate protected arms through so-called licensing structures. Peterson then took that case all the way to the Supreme Court and he sought review of what the Fifth Circuit said. But as we've discussed previously in other videos, the warning signs were really there because the government actually waived their response at the Supreme Court level, and the Supreme Court actually never even ordered them to file a response. This then went to conference, and then the following order list, it was denied. And again, this all happened despite the fact you even had some amicus briefs filed by various 2A organizations advocating for the Supreme Court to review this issue. And because of that denial, we are now seeing the direct consequences of what has happened. The federal district court, in this case, the judge here, has now denied Mr. Peterson's motion to extend his surrender date and has actually ordered him to self-surrender on May 20th, 2026 at a facility designated by the Bureau of Prisons. The court specifically stated that Mr. Peterson had ample time to prepare and denied the request for additional time. So after years of litigation, the Supreme Court's refusal to intervene now means that this individual here, Mr. Peterson, faces actual prison time tied directly to the ATF's enforcement of suppressor regulations against solvent traps. And again, this involves a single solvent trap that wasn't registered. They're claiming that that's a suppressor. The Fifth Circuit upheld this. They said that this type of restriction fits within broad shall issue licensing schemes, and therefore they upheld the NFA. But now some other things have developed in this case. Mr. Peterson is continuing to challenge his conviction based on ineffective assistance of counsel. Now, one issue that I've mentioned in earlier videos, some of the earliest videos where I was covering this case, was essentially that his original attorney during the district court proceedings and then also during the original Fifth Circuit appeal process actually failed to properly raise some critical Second Amendment arguments and failed to even mention the Supreme Court's Bruen ruling. And remember, the timing here is critical because Bruen was not this obscure lower court opinion. It was in place, I believe, for a couple years, and it was this binding Supreme Court precedent surrounding the Second Amendment, which really reshaped the landscape about how these types of cases need to be analyzed. It was the newest and most controlling Supreme Court precedent governing the Second Amendment, and the Supreme Court had completely reshaped the legal framework when it comes to these types of firearms cases, especially when you're bringing a two-way claim. But in this case, originally his counsel did not even mention or reference Bruen once. Instead, the attorney relied exclusively on the older strict scrutiny, balancing of interest tests as well. In fact, this error was even pointed to by the ATF at the lower court level and then also even on appeal in front of the Fifth Circuit. So even the ATF recognized that the Second Amendment review of this case was not being done properly under the Bruen framework. And this matters because Bruen fundamentally changed how courts are supposed to analyze these types of firearms regulations. The Supreme Court rejected balancing tests and interest balancing approaches that lower courts have been using for years. Instead, the court said that the government must justify these types of firearms restrictions through the nation's historical tradition of firearms regulations, and that was a major shift. So Peterson is essentially arguing that his original defense failed to fully invoke the strongest and most binding Second Amendment authority available at the time. And now this issue may become part of the future kind of post-conviction proceedings in this case. Now, to be clear, the Supreme Court denial ends the cert petition stage of this case, but the ineffective assistance of counsel claims operate a little bit different. It could potentially also help him to not have to report, but as of right now, he is being ordered to report, but there could be some changes that happen after the fact. These types of challenges can sometimes continue through, collateral review proceedings, habeas petitions, or other post-conviction litigation. So while the Supreme Court refused to take up the broader NFA challenge, Peterson may continue fighting aspects of his conviction through these types of separate claims. And specifically, the argument appears to focus on whether the original defense adequately actually litigated the Second Amendment issue that was being raised, or if it actually failed to do so because Bruen was not mentioned even once. So the Peterson case continues to evolve even after the Supreme Court denied review in this case. Peterson now has been ordered to self-surrender later this month, and the Fifth Circuit ruling upholding that NFA restriction currently remains intact. But now a new fight is emerging over whether Peterson's conviction was proper because his original defense failed to raise the most important Second Amendment arguments available at the time and failed to even mention binding Supreme Court precedent. And that means this case may still continue impacting future NFA litigation moving forward, and there's potentially still a hope for Mr. Peterson to avoid this type of prison time. So as soon as we get new filings and developments in this case, I will let you guys know, but unfortunately, this is the situation. This is what is now developed because of the Fifth Circuit ruling and because of the Supreme Court denied review in this case. So as we get more information, as this unravels more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this content, and so it shares it with more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.